Thank you, Chief Justice, and may it please the court. My name is Will McDonald, and I represent the petitioners in this matter, Georgia Lee and Jack Dawes. At this moment, I would like to reserve 2 minutes for rebuttal. Thank you. This court should reverse the 13th Circuit's decision and hold that the school district sniff policy subjected students to randomized, close proximity canine sniffs without individualized suspicion, which is unreasonable and unconstitutional pursuant to the Fourth Amendment. This court should find that the school search policy was unreasonable for 3 reasons. First, the Eastland County School District's canine sweep policy is unconstitutional because it authorizes intrusive searches without individualized suspicion. Second, the district court cannot justify these searches based on the special needs doctrine. And third, even if the special needs doctrine does apply, the policy is still unreasonable because it imposes an excessive intrusion on students' substantial privacy interest with little evidence that is effective or necessary. This case concerns the preservation of constitutional boundaries in schools. The Fourth Amendment does not allow suspicionless public canine body sniffs of students solely to deter contraband. Students retain their rights even while at school. If the court permits this policy to remain, it will undermine both the dignity and legal protections that students deserve. First, the policy is unconstitutional because it authorizes searches without individualized suspicion. The Fourth Amendment generally prohibits searches without individualized suspicion. This court has only allowed very narrow exceptions, such as for airport screenings or DUI checkpoints, when a person's expectation is already diminished. This court established in New Jersey versus TLO that school officials are permitted to search students when there are reasonable grounds for suspecting that a student has violated the law or school rules. This means that there must be a causal connection between the search and the student and the suspicion surrounding the search. Here, the district had no such grounds. The canine sniffs were conducted randomly and without cause. Students such as Georgia Lee were chosen not due to any behavior or red flags, but rather because their classroom was picked at random. This information can be seen on pages 5 and 6 of the record. There was no evidence of the students using drugs prior to the searches, as seen on pages 6 through 8. This is not a constitutionally valid reason for a search. Additionally, it was not merely an inconspicuous check, as it involved law enforcement conducting close proximity sniffs of students' bodies in front of their peers. Such actions cannot be considered minimally intrusive under any circumstances. Secondly, the special needs doctrine does not apply because the program's primary purpose is law enforcement. This rule was established in Chandler versus Miller and Ferguson versus City of Charleston. This court struck down suspicionless searches and drug testing schemes because the government's true aim was to detect and punish criminal activity. The same is true here today. The canine sniff was handled by the Sheriff's Department, as seen on pages 4 of the record. Alerts go directly to law enforcement, and flag students face interrogation and possible discipline. This is not a limited safety-based exception, but instead it is a broad law enforcement policy falling outside of the limited cases justifying suspicionless searches under the special needs doctrine. Third and finally, even if the special needs doctrine applied, the policy still fails the reasonable balancing test established in Board of Education versus Earls. In Earls, this court provided a 4-part balancing test. First, the nature of the privacy interest at stake, the character of the intrusion, the nature and immediacy of the government's concern, and fourth, the efficiency of the search in meeting that concern. In a direct application of those factors to the facts of this case, the character of this intrusion is far more aggressive than anything this court has previously allowed in the public school context. In Vernonia, students gave urine samples in bathroom stalls with limited visibility, while in this case, Miss Lees and Mr. Dawes were subject to a public sniffing by a police-trained dog in front of their friends, teachers, and other law enforcement. Every student in the room had been shown how to identify an alert, therefore each student knew what it meant when the dog stopped at Miss Lee's desk. This led to classmates laughing and mocking Miss Lees, as seen on pages 6 and 7 of the record. She was then paraded out of the classroom and sent directly to the principal's office due to the alert. Worse, The results were shared with law enforcement, as seen on pages 4 of the record, even though no contraband was found. Unlike in Earls, where results were kept confidential, Eastland County School District's policy broadcast alerts to the entire class and then forwards them to the police. Secondly, the searches were more intrusive than necessary. Eastland County School District did not implement any safeguards for students' privacy as they did in Vernonia. In Vernonia, like stated above, students were provided the privacy of conducting the urine test in a private bathroom, while here the searches were performed in front of the students in their classrooms. This court held in Earls that keeping the results confidential was a requirement to ensure that privacy interests were not violated. Here, as seen on pages 6 through 8 of the record of the results were in front of the entire class and each student knew what the alerts meant. The alleged interest, while deterring the use of drugs is an important interest to the government, this important interest does not equate to the intrusive nature of the sniff policy. As seen on pages 4 of the record, the school district admitted that the original canine policy was successful, therefore making the new policy unreasonable and unnecessary. Finally, the effectiveness of the expanded policy was minimal at most. Only a slight increase was seen in detections and often produced false positives, therefore leading to the humiliation of other students. In conclusion, the Fourth Amendment protects against exactly this kind of suspicionless public intrusion on the individual. And while schools deserve flexibility, that flexibility ends where students' constitutional rights begins. We ask this court to reverse and hold that the Eastland County School District search policy is unconstitutional. Thank you.